Microphone check. Microphone test. One, two, three. Mic check. One, two, three. Microphone check. Number two, microphone check. One, two, three. Microphone check. One, two, three. Good morning. Microphone check number two. Microphone check one, two, three. Mic check one, two, three.
Mr. Robinson, can you hear me?
I can.
Perfect. All right. I just want
Welcome to the March 31st, 2023 meeting of the Texas Commission on Environmental Quality. It is 9:30 a.m. I am joined by my colleague, Bobby Janeka, and our General Counsel, Mary Smith. My name is, and our Public Interest Counsel, Garrett Arthur. My name is Emily Lindley, also Commissioner here at TCEQ. Since we are holding this meeting partly over a webinar, I'd like to remind folks to keep their phones on mute when they are not speaking so that everyone can hear the meeting. For each item that argument or discussion is allowed, we'll inform the parties and the public of the time limits for their discussion. Registration closed at 9:30, but if you would like to address the commission on a particular item, please email agenda@tceq.texas.gov with your name, affiliation, and the item that you would like to comment on. We will do our best to accommodate that request. For those making presentations, please wait to begin your presentation until I've asked you to begin, and please check to make sure your line is unmuted before proceeding. Ms. Smith, if you'll please call the first item.
Item number 1 is the application by Harris County Municipal Utility District number 542 for major amendment of TIPD's permit number WQ00153-12001 to authorize an increase in discharge of treated domestic wastewater. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
In this matter, Harris County MUD number 542 is seeking a major amendment to its domestic wastewater discharge permit. The Water Code and our rules require that a contested case hearing request must be based on a comment raised during the comment period. In this case, the hearing requester's comment simply asked for a contested case hearing but failed to raise any substantive issues with the permit application. Therefore, in my opinion, we should deny this request. I have reviewed the draft permit, the response to comments, and the other backup material, and I would be supportive of issuing the draft permit as recommended by the ED, as well as adopting the ED's comments, but I welcome any thoughts or comments you have.
I'm in agreement. I could make the motion,
Okay.
therefore. I want to make sure we follow the process. Is this the type of matter we hear from other parties on, or we proceed? I will make the motion that we deny the hearing request filed by Mary Jo and Rusty Stavanoa and issue the draft permit as recommended by the executive director.
I second. All those in favor?
Aye.
Ms. Smith, if you'll call the next item.
Item number 2 is the application by Roman Haas Texas Incorporated for renewal and major amendment of Texas Pollutant Discharge Elimination System permit number WQ0000458-000. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Thank you. I'll offer my few thoughts here at the beginning as well. This applicant seeking a renewal and a major amendment of its industrial wastewater discharge permit. For this item, we only have one requester, the Bayou City Waterkeeper. As you know, for a group to have standing, they must identify a member who would have standing to request a hearing in their own right. The Bayou City Waterkeeper failed to identify any member who might have standing, so I believe the request must be denied. Because they didn't meet those requirements for the group association standing in 30 TAC 55.205. Again, I've reviewed the draft permit, the response to comments, and the other backup, and I would issue the permit and adopt the executive director's response to comments.
Again, I'm entirely in agreement. The single requester here didn't meet the clear statutory requirement.
Yeah.
I would, therefore, also make a motion that we deny the hearing request filed by Bayou City Waterkeeper, issue the renewal and major amendment of TPDES permit number WQ0000458-000 to Rome and Haas Texas Incorporated, as recommended by the executive director, and adopt the executive director's response to comments.
I second. All those in favor? Aye.
Aye.
Ms. Smith, if you'll call item 3.
Item number 3 is the application by Undyne Texas Environmental LLC for new TIPD's permit number WQ001-6046001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Few more people commented on this one, so I have a little bit longer comments than before. Again, this applicant's seeking a domestic wastewater discharge permit, and for those kind of permits, hearing requests, we have to determine first who is entitled to and contest a case hearing. And then if we do find that a requester is found, we will need to discuss those issues. So for starters, for Ronnie Jean Autry, I would agree with the executive director in OPIC that given the size and the nature of this discharge, the fact that his property is next to the beginning of the discharge route, and the relevant concerns he raised regarding his water well and his personal health, that he isn't affected in a matter different than the general public, and he's raised timely and relevant issues. So I would refer him to SOA for a contested case hearing. I also agree with OPIC and the executive director that we should refer Brazoria County. The discharge route is entirely within Brazoria County, and the county has raised water quality concerns regarding the permit application. There's several individuals who OPIC recommended granting, but the executive director recommended denying. I've reviewed the requests and believe that they should be denied. Jamie, I hope I say this correctly, Ballard, I believe, lives upstream from the discharge and simply states that he does not believe wastewater should be allowed to be discharged into waterways and that wildlife should be protected. I don't believe he articulated a personal interest. Kevin Buchanan lives upstream from the discharge and fails to articulate how he would be personally affected. Kathy Cagle expresses general concerns for wildlife and those swimming in the discharge route, but fails to show how she'll be personally affected. And lastly, Michael Wayne Durham and Stephanie Durham live about 2.8 miles from the proposed facility and raise concerns regarding the impacts of the proposed facility on the Bastrop Bayou. Based on the size, nature, and distance of the proposed discharge from the Durham's residence, I don't believe that they'll be affected in a matter different than the general public. So I would not grant a hearing to those individuals. The remaining hearing requesters identified generalized concerns, and to me, they fail to show how they would be personally affected in a matter different than the general public. So I believe they should be denied. So I come down with Mr. Autry and Brazoria County for a referral to SOA for a hearing and deny the rest.
I'm in agreement, and I appreciate you highlighting my same analysis I followed on those requesters who were within closer geographical distance. The deciding factor clearly in my mind was whether you're on the discharge route or in a location just from the size and details of the facility were not likely to be impacted different than the public. So I would agree with you about Ronnie Jean Autry and also Brazoria County for the reasons you stated.
Okay, I will move on to the issues. I believe the affected requesters have essentially raised 3 overarching issues. That includes whether draft permits protective of water quality under the applicable surface water quality standards, including designated uses of the waters in the discharge route and groundwater. 2, whether draft permit is protective of human health. And 3, whether draft permit is protective of aquatic life, wildlife and livestock near the discharge route. The county raised other issues in its hearing requests. Most were not raised in a timely public comment, so we can't refer those. And I do not recommend referring a separate standalone issue on recreation. I believe that the relevant aspects of that concern are contained within the issue of whether the draft permit is protective of water quality and the existing uses of the receiving stream and human health. And as you know, the commission doesn't have authority to consider property value or flooding by the receiving stream, so I would not refer those issues either. So, welcome any thoughts on that?
Well said, thanks. I agree on those issues and particularly the framing of them and what aspects or items from the requesters you would exclude in the questions.
Okay, lastly, I guess I would just, 2 more things. We did have several requests for reconsideration. I believe those requests I believe that the requests either raise issues that are not relevant to our decision on the application or that they're adequately addressed by the ED's response to comments or in the issues that we're going to be sending over to SOA. So I would deny those requests for consideration. And then lastly, it's a small number of affected persons, so I would also offer up a referral to ADR on this one. So,
Agreed on both counts?
okay, I can make a motion, or you can.
I think my motion will capture and reflect yours, but
Okay.
please let me know if there
Okay.
was anything different on the issues that you saw differently. I move that we grant the hearing requests of Ronnie Jean Autry and Brazoria County, deny all other hearing requests and requests for reconsideration, refer the application to SOA for a contested case hearing on the following issues. Issue 1, whether the draft permit will be protective of surface water quality and preserve the designated uses of the discharge route in accordance with the Texas Surface Water Quality Standards and be protective of groundwater in the area. Issue 2, whether the draft permit is protective of human health of residents in the immediate vicinity of the proposed facility and the immediate discharge route. Issue 3, whether the draft permit is protective of aquatic life, wildlife, and livestock in immediate vicinity of the proposed facility and discharge route. I further move that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA's scheduling process, and finally, that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second. All those in favor?
Aye.
Motion carries. Ms. Smith, if you'll call item 4.
Good morning.
We'll give everybody a chance to get up and to the table and set up. Item number 4 is the petition for the creation of Austin County Municipal Management District Number 1. The petitioners seek the district's creation and should present the matter, followed by any interested persons. Presently, we don't have anyone else signed in. The ED and then OPIC. Each party will have 5 minutes for their presentation, and the petitioners may save time for rebuttal as they bear the burden of proof. And so I guess we'll begin with the petitioner, and I understand Mr. Stephen Robinson is on the line to present for them.
Yes, correct. This is Stephen Robinson. Can you hear me?
Yes. Thank you.
All right. My name is Stephen Robinson. I'm an attorney with Allen Boone Humphreys Robinson, and I'm here on behalf of the petitioners, Beckendorf, Columbus, Faruqi, LLC, Austin County, NKFS, LLC, and Zashco Fuels, Inc., who are the owners of all of the property within the boundaries of the proposed district. They have filed a petition with the Commission for the creation of Austin County Municipal Management District Number 1, pursuant to Chapter 375 of the Texas Local Government Code. This is a 291.53 acre tract in unincorporated Austin County, located in the Houston Metropolitan Statistical Area. This project is located in an area that with no public infrastructure providing water, sewer, or any other public infrastructure. The petitioner has filed a petition which meets all applicable requirements of Section 375.022 of the Local Government Code and of the TCEQ rules under 293.11J. So on behalf of the petitioners, we respectfully request the approval of the petition for the creation of Austin County Municipal Management District Number 1.
We'll save you the remainder of your time. I had
Go ahead.
a question right out of the gate. You mentioned there were no services in the district, no public infrastructure in the area within which this proposed district would be created. And I note that it's a municipal management district, which I did my best to search our records and look back, try to see where typically those have existed over municipal boundaries or extra jurisdictional areas of ETJs of existing municipalities. So I appreciate that your firm has clearly sees that these districts can be used to develop raw land, I believe, but I'm curious where you see it in terms of this fitting into the context of, are there precedents elsewhere in Texas where these particular districts have existed outside of municipalities? Can you point me there, because I was not able to find any precedents?
Sure. So Just a little bit of statutory history. There was the original Municipal Management District Act was passed in 1991. It did have area restrictions in it, which would have not prevented the creation in an unincorporated area. The statute was amended in 2011 to remove all area restrictions. I will note both that the TCEQ rules actually recognize that the districts can be created outside the boundaries of a city in its recognition that you only need a consent if you are in the city. There is no corresponding restriction on the use of the MMD outside of the boundaries of the city or the ETJ. And so there is no restriction. They have been used in very similar circumstances for raw land development. And I do not believe there is a relevant statutory or regulatory restriction that would distinguish between whether or not a project is within the boundaries of the city's ETJ or in the unincorporated area of the county.
I appreciate that, and I think your answer gave me the answer to a question I had about another statutory provision. You said it meets all requirements of our state law and our agency's rules, but you alluded to the obligation under the law to have an interaction and permission from the municipality, and so you interpret the rules that the absence of that municipality means you aren't required to show. I think some members of the public may see that and interpret alternatively that if you don't have a municipality who can give permission, that you can't satisfy that requirement. So I wonder if you could square that circle with me. It sounds like you're clearly interpreting the law differently.
Sure. There are several other locations, including related to the creation of municipal utility districts, where the law would say that you must receive consent in order of the municipality, but it doesn't say the alternative, that if you're not in a municipality, that you don't have to get a consent, but it's always been interpreted that way. So there is no restriction on the ability to create outside of a city's ETJ, and there is no legal authority for a city to have any municipal control over an area outside of their ETJ. I will note that language predated the 2011 amendment. So at the time it was included, it may have been relevant. At this point, and in fact, your rules actually even recognize that it does not have to be in a city to be created. But I believe what I would call that language is surplus language that at a time had a relevance prior to the 2011 amendment, but has no relevance at this point.
I appreciate that. Thank you for that answer. Mr. Robinson, I wonder, I had another question. Can you speak to this particular type of district? Are there particular authorizations or authorities that your client sees as necessary for this type of district versus other districts that have a more clear precedent of being created outside of municipal boundaries? What's the benefit gained?
Yeah, very, very good question, because this was a very deliberate decision. As you may know, that the Texas Constitution was amended to permit districts to, like a municipal utility district, to do parks and recreation and open space financings in only certain counties. So we're in an MSA, and obviously Austin County is in the Houston MSA, but when you cross just to the east of County into Austin County, or Waller County into Austin County, you go from a developer being able to proactively provide open space and parks through the financing with utility districts to an area that does not have that or is not permitted to do that. One of the important pieces of or distinctions with a municipal management district is that it has the ability to not only levy a tax, but also to do an assessment. And those assessments are not restricted for their use for parks and recreation and open space. And so the ability to do assessments through a municipal management district is an important distinction and results in some important outcomes for the community and landowners by giving us the ability to provide more quality development with open space, parks, and recreational facilities.
I appreciate that answer. Thank you. Commissioner Lilly?
I think you asked all the questions I would ask for right now. And thanks, Mr. Robinson, for those responses. I guess let's keep going down our list.
Yeah, will we hear from other parties? I guess one
Yeah.
final question for me, and I may return this as we discuss what we want to do on this item, but I'm curious, you mentioned that it has been interpreted, the Local Government Code 375.022C6. I'm curious to know, where has it been interpreted the way that you suggested, where the absence of municipality can satisfy the requirement to get permission from that municipality? And I just ask if there's any particular citations or examples, precedents that you could provide. And you may have other people working with you in the background, so I'll ask now so you can see if there's a possibility to get that answered. Do we have will we hear from other parties?
Yeah, nobody's signed in on this, so that means we would go to the ED next.
Yeah. Mr. Robinson, do you want to address
Sure.
that question now,
You know,
or do you want us to come
I'm
back?
I'm not sure that we have where a municipal management district has been created through the TCQ in an unincorporated area, but certainly, and then not required a consent of a municipality. I would first say that because there is no territorial or limitation in the statute or in your rules on the location, that it is illogical to require the consent of a municipality that does not have any regulatory jurisdiction. And similarly, and probably by analogy, you would provide that where a consent is required to the creation of a municipal utility district, but it has clearly many times been created outside of the city or city ETJ, and no consent has been required, that by analogy, it has been read to not apply outside of a city or a city's ETJ in other contexts.
I have one quick question, actually. And I apologize if you've already spoken to this, but will it be within a municipality at some point in the future? Say if Sealy or another nearby municipality, does anyone intend to annex this area anytime soon?
We're not aware of any intention. We do know that to the east of this track, even within the city's corporate limits and in the city's ETJ, they're unable to provide utility services. And so the tracks to the east would need to be annexed first in order to have the ability to annex this track. But the lack of availability of utilities is restricting the ability for this property to be developed. And there is no provider that has the capability of providing those. But we are not aware of an annexation plan by the city that would allow this to be annexed. But certainly, We are to the west of Sealy, and it could be at some point in the future, but there are actions beyond the control of our landowner that would dictate whether that could happen.
Okay, thanks. Since there aren't any other interested parties, we'll go on to the ED, and I'll just go ahead and ask one question, because I do have one, and I heard Mr. Robinson, and I don't necessarily, I'm not sure if I, agree or disagree with everything he said quite yet. I just still have some questions about the statutory purposes of a MMD. A requirement for creation, how do I say this? Okay, and how it comes across to me is that an MMD, I can't figure out why they've chosen to go the MMD route as opposed to a MUD, because an MMD, it sounds like they have to have this, something from a support from municipality, and that's not there. And what Mr. Robinson was saying is because there is no municipality, right? And so how can something that doesn't exist provide, them with documentation that they would need for this application? And I think Commissioner was trying to ask, Commissioner Janetka, I don't want to put words in your mouth, but it sounds like he was trying to ask, are there examples of this in the past? Because one's never come before us, and where someone doesn't have something from a municipality seeking to do an MMD. And Mr. Robinson's made it sound like, but those have occurred in the past. But we haven't seen that. So I'm just trying to reconcile why the MMD route and not a MUD. And there is a requirement, for some sort of documentation to exist, and it's not there. And it sounds like because there would be no entity to get that documentation from. But I don't know if I'm making a whole lot of sense. I'm trying to reconcile all that. So I do want y'all to speak to that. But if that's part of your presentation as well, you can just give your presentation.
Well, I can do either. So I'll go ahead and try and answer your questions. I'm Kayla Murray, an attorney with the Environmental Law Division, and with me is Justin Tack with the district section. I can't speak as to why the applicant chose an MMD over any other type of district. When you do read 375 as a whole, it does seem to indicate that this type of district should be inside a municipality. But we can also see the interpretation of when that statutory language was removed regarding the location of this type of district, that removed location requirements overall. So
And that's the 2011 amendment?
That's the
Okay.
2011. It was 375-021. And then I think you may have had another question. I can't remember.
Well,
what
I
it was.
blabbed, but no, that basically gets to the heart of my question.
Oh, I remember what it was.
yeah.
If there was any precedent, the
Yeah.
only precedent we could find was Sun Lake Improvement District, and 375 allows these types of districts to be called municipal management or improvement districts. And Sun Lake was within the ETJ of a city, not within the corporate limits, but at least within ETJ. And that was in 2021 that order was issued. So that's the only precedent we can offer right now. So, but I'll go ahead and just
Yeah.
do my quick little
Thank you. Yeah.
presentation. Again, I'm Kayla Murray, an attorney with the Environmental Law Division, representing the executive director, and with me is Justin Tack with the district section. The executive director received a petition from Beckendorf Columbus Fairquai LLC, Jasco Fuels, and Austin County NKFS for the creation of Austin County Municipal Management District Number 1 pursuant to Chapter 375 of the Texas Local Government Code. We have reviewed the petition and concluded that the creation of the district would be feasible and necessary and a benefit to the land to be included in the district. Additionally, because the petitioner seeks to create an MMD outside the city limits of a municipality, the ED discussed with the petitioners whether Chapter 375 of the Local Government Code allows the creation of MMDs that are outside of a municipality, and whether the proposed Austin County MMD can operate as an MMD pursuant to the provisions of Local Government Code 375 outside of a municipal boundary. The petitioner has represented to ED staff that it is their position that Chapter 375 does allow for the creation of an MMD outside of a municipal boundary, and that they believe they can operate the MMD effectively outside of a municipality. Based on these representations and the information provided with the creation petition, the ED recommends granting the petition for district creation. And we are available if you have any other questions. Thank you.
I had one question, though, just, can you help me understand in more plain language the distinction of the municipal management district versus regular MUD that Mr. Robinson alluded to, of being able to provide an assessment, or is it implement an assessment? Or I'm not sure exactly the right way to put it. Can you speak to that? What is it just an extra tax, an extra fee?
I'm going to defer to Justin Tack on this.
Thank you.
Yeah.
Good morning, Commissioners, General Counsel, Public Interest Counsel. For the record, I'm Justin Tack with the district section. Assessments are similar to taxes. They're just assessed in a different way. They're assessed on usually square footage, and Mr. Robinson can correct me if I'm wrong. But I think maybe to answer both questions, what I heard from Mr. Robinson was, if we were to create a MUD, or if the petitioner was to create a MUD in Austin County, some of the limitations on recreational facilities and some of the things that they may want to do with their land plan as far as offering amenities and those types of things, and funding those, whether it be through assessments or taxes, by the Constitution and the statutes, they would not be able to do that with a standard MUD. Austin County is not one of the counties that's listed that is able to issue bonds to cover that debt. So I don't want to speak for the petitioners, but I believe I heard Mr. Robinson say that was one of the main focuses of theirs, maybe offering amenity packages that could potentially be funded by a municipal management district. Municipal management districts have different powers than MUDs, and therefore the statutory and the constitutional requirements of recreational facilities wouldn't necessarily apply to them. So they could theoretically issue debt for those types of facilities.
I appreciate that. That's really helpful, and I think that complicates the decision a little bit in my mind, because understanding that there's arguably a limitation in the availability of services for developers through our standard MUD posture or template does put this in a different light contextually. But we come back around to the issues and tension that I think you've seen at many of the hearings you've been called to as a resource witness, but attending for our agency at Sunset. So thank you. That was your
Yeah, I
question.
have one or two questions, and real quick, Justin, what you were just saying, I had a follow-up question. So how, if it's bonds that are issued, is that what you were kind of saying? That could be something, and I know it's a hypothetical, but are those voted on? I mean, how does that work eventually? And maybe I don't know, I might be going down a wormhole, but how is that debt issued? And then do people get to vote on it, or how would that work?
Yeah, so we don't see a lot of recreational facility types with MMDs, because by statute, we can only review bond issues for MMDs, bonds for water, wastewater, and drainage at the time, currently. But typically how, and Mr. Robinson can correct me if I'm wrong, but a standard MUD and an MMD, when they go to confirm the district's creation, the voters at the time also authorize the taxes, the maximum tax rate that they will be subject to, the amount of water, wastewater, drainage bonds, the amount of recreational bonds, and the amount of road bonds, essentially any bonds that they intend to potentially issue in the future, those voters authorize those limits.
Okay, and then one other quick question. And if you don't know this, Mr. Robinson might very well, so I'll give an opportunity to chime in. But this language in 2011 that was amended, do you know the bill number?
Yes.
Okay.
Senate Bill 1234 from the 82nd legislation.
Hard to remember, yes.
I was
got
the
it.
BA on that bill too, by the way.
You still have dreams about it?
I had
sounds like.
nightmares.
Yeah.
Yeah.
For those
Sounds-
For those playing along at
sounds
home who
that
don't understand our agency's process, the BA means the poor expert in our agency who drew the short straw and has to be the bill analyst on, they're the point of he got all the abuse for the urgent questions about the bill in the bowels of our agency is the,
And it wasn't just one section, it was like 40.
Again, you still remember it very well. Okay. I'm gonna take a quick timeout. I need to look over. Oh, yes, no, I do want to do that. OPIC, I would like your thoughts before I take a timeout. Thank you.
Good morning, Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. Based on this record, OPIC agrees with the ED's conclusion that the proposed district would be feasible, practicable, and beneficial to the included land. We support the ED's recommendation to grant the petition and issue the proposed commission order.
Thank you. Mr. Robinson, I know you still have a little bit of time. I think it's 3.5 minutes, or is it a minute and a half? 3 minutes and 30 seconds for rebuttal. So I'll let you have the floor.
Sure. So really just confirming what has been said is the distinction, significant distinction, is the ability to levy assessments, which give us the ability to allocate the cost of all of the open space and parks and recreational facilities on an assessment basis for all of the property owners within the district, thereby being able to do what we could do in all of the counties to the east, and that is to have public facilities that are owned by the district that support open space, parks, and recreational facilities, which we would not be able to do with a municipal utility district or a water control and improvement district or other special districts. So it does provide a very important distinction. There are some broader services, things, whether or not the board will elect to use any of those is for a future decision. But as Justin pointed out, there are statutory differences in their operation that can be provided. So when we look at this, we say, one, we have an area that a landowner would like to develop. We have no provider of public water or sewer available, and we would like to have a district to have the capability to do that, but we would also like to be able to make this as good as possible, having the amenities that are now expected, particularly in the Houston market. So all of those decisions led us to this. But what I would primarily point out is there is no statutory or regulatory restriction on the location. It may have historically been used within metropolitan areas. It has been dramatically expanded. We have many, many examples in cities, ETJ, particularly of districts, of municipal management districts that are created in the ETJ. This may be the first time that there has been one outside of a city's ETJ or corporate limits, but I don't believe that creates a restriction because there is not an area restriction within the statute or the rules, and we would respectfully request that the petition be granted on this matter.
Thank you for that. Commissioner Janicka, I think I still just want to take a minute or two to gather my thoughts real quick. So, just a minute. Let's recess for 5 minutes. Would that be okay with you, Commissioner? Okay, well,
Thank you.
it's...
Thanks.
Do you need more time than that? Okay, let's take a recess for 5 minutes real quick. one more minute. and reset. Okay, thanks for indulging my recess. I really appreciate the discussion, both from Edie and Mr. Robinson. I needed it. It helped me understand things a little better. And so with that, I would be comfortable granting the creation of the district. You're agreeing? Okay, then I will offer a motion.
Well,
Go ahead.
Yeah. Doing that, yikes. So this is, let me say here to all of our beloved staff in the audience, members of the public, people following along at home, this is the most boring, exciting discussion in terms of where the state of Texas wants to have its vibrant economy and the feeling of Texas and private property rights, being able to make sure you've got your patch of the state. And this issue is alive and well, not just here, there's a fight going on all around, and this is an important request that certainly requires full consideration. We're embarking on something, I think, a little bit new. And so I wanted to ask Mr. Robinson if I could, before we ventured past this threshold, there's a specific provision in the statute, and I appreciate that your interpretation of the obligation to have permission from a municipality and the absence of any underlying municipality means you're relieved of that obligation. There is, however, in statute 375.024, publication of notice, and I presume that was local government code, what we were talking about earlier, a requirement, no, not publication notice at all. There's a reports section. I've got a lot of good detail out of it in front of me. 375.315, effectiveness study report. The board of an authority shall study the effectiveness of the authority. Not later than December 31st of each even-numbered year, the board of an authority shall report to the legislature. And because this is a report to the legislature, I want to get you on the record about your understanding of the law, your obligations under it, to report to the legislature so that I can answer to them if they have sharp questions for us about this decision today. Section 375, 315, down in there, B, I don't want to butcher the exact nomenclature of where it resides in there, but there's a requirement to report areas in the municipality that created the authority that are not in the authority. And I just wanted to get your interpretation of that requirement to report to the legislature on that. Would you intend to be explicit in how you will report to the legislature that you are not over a municipality, or would you anticipate that your report might, since you're not applicable to the obligation, you might just leave it off the report? How do you think you would handle and interpret that obligation under the law?
Yeah, we would go straight down the list of requirements and comply with each one. Obviously, the one that says, listing as it relates to the municipality, it would indicate that we are not within a municipality. And we obviously have quite a few, MMDs that are not in municipalities. We have lots of they are in the ETJ. And so,
Okay.
So the same answer applies there. But what I would say is we will fully comply with all of the statutory requirements here for reporting, et cetera. And where this was drafted in 1991 for things that were specifically in a city, when that changed and then some sections no longer are logical.
Yes, sir.
They obviously then, you would just indicate, for instance, it's not within a municipality.
I'm very glad to hear it. That language of the law that I just quoted you was added in 2011. So I hope that doesn't fall afoul of your interpretation of how it's no longer applicable. But that's helpful to hear, and I will just rest assured I'll be watching closely to see how the neighbors of your project and then the members in the legislature react, because I think we take seriously suggestions from the discussion around the public around this particular regulatory space that we guard, where our agency is accused of being a rubber stamp in issuing districts. We're open year-round. We're one of two options, the legislature or our agency, to create special districts, to create new government outside of municipalities, outside of the existing traditional forms of government. I take seriously that we do scrutinize every factor that we are able to scrutinize. And I think that where the public perception is that we are a rubber stamp reflects the limitations that we're able to apply to review and scrutinize these districts, and the manner in which we do so. We do it to the full degree that we are currently required to do so, where members of the public are upset and there's issues of traffic and other issues that are outside of our review and tend to, like the permits we issue, be outside of our agency's purview and leave the unhappy taste in the mouth. I think that's the real answer, the explanation. But this is the sort of decision that really gives me pause in this policy space, because you're asking us to move forward in creating a district in an arguably potentially novel way that I agree serves a vital need in developing and offering needed areas to live and recreate in our state, but just raises questions of, are we following the most appropriate process? So I appreciate your being forthright, and I would just encourage you to be as explicit in any reports to the legislature as you can. If you might look a little different, be clear about that, because if the legislative staff and members get the sense that you are, in fact, trying to come through our agency in a manner to evade their oversight, I suspect they would not be pleased. So I appreciate it, and Commissioner Lindley, I'll hand it back to you.
Yeah, thanks. I would just add, I think, one small lesson learned here today is that if people are going to come to us with MMDs, because I do not, let me just speak from my perspective, I don't see them very often. Having examples in the backup would have been helpful. I think that probably would have helped me out. Wouldn't have known that
Not
until
required,
today.
and yeah, good to know first.
But with that, I still have a motion, and I'll see if you are in agreement. I would move that we grant the petition for the creation of Austin County Municipal District Number 1 and issue the executive director's, Austin County Municipal Management District Number 1, and that we issue the executive director's recommended commission order for creating the district and appointing 5 initial directors, correcting the spelling of Mayor Kwadumi's name. That's the end of my motion.
I second the motion and will only add that I appreciate in reaching that motion, one factor is certainly that this item is uncontested. And I believe the
Yes.
petitioners have demonstrated a need for the creation of the district. So I second the motion.
Okay, all those in favor? Aye?
Aye.
All right, thanks. Okay, well, let's move on to, thank you, Mr. Robinson, to item number 5. Ms. Smith, if you'll call the item.
Item number 5 is a resolution to fill 17 of 41 membership positions on the Galveston Bay Council, and the executive director's staff is here to present this item.
Go ahead, thank you.
Okay. Good morning, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Lisa Marshall with the Water Quality Planning Division in the Office of Water. With me today is Aubrey Puelka with the Environmental Law Division. We're here today to request your consideration to approve a resolution to fill 17 of the 41 membership positions on the Galveston Bay Council. The Galveston Bay Council is a 41-member advisory body to the Commission whose function is to advise the Commission on the implementation of the Galveston Bay Plan, or the Comprehensive Conservation and Management Plan for Galveston Bay. Members serve 4-year terms, and the terms are staggered such that approximately half of the terms expire at the same time. The members of the Galveston Bay Council represent diverse areas of interest in accordance with Federal Clean Water Act Section 320. The Galveston Bay Council is representative of federal, state, and local governments, research and academia, the private sector, and environmental and citizen groups. The 17 nominees were either selected by the executive director of their respective agency or entity, or his or her delegate, or solicited and reviewed by the Galveston Bay Council Nominations Subcommittee and submitted to the Galveston Bay Council to determine which nominees to recommend to the Commission for consideration. We respectfully request approval of a resolution to fill 17 of the 41 membership positions on the Galveston Bay Council. Thank you for your consideration, and we are available to answer any questions you may have at this time.
Thank you. I don't have any questions. You?
No questions other than to want to make sure that we're very, very explicit in recognizing and thanking all the members who have agreed to serve. Your hard work in helping manage the covering such a wide collection of interests and entities. It's very important, but it's a really critically important conversation. I was just looking back in my notes. I vaguely recall a former colleague of mine, friend, Mickey Leland, intern with the program, and I heard at that time how important and involved with the community it is. So I appreciate the efforts going into keeping this council staffed and current.
Thanks. Ms. Smith, has anyone signed in on this item?
No one signed in on this one.
Mr. Arthur?
OPIC supports approval of the resolution as recommended by the ED.
Yeah, I'm in agreement with ED and OPIC. I'm prepared to move forward with adopting the proposed resolution today. And again, I ditto what you were saying, which is thanking everyone for participating on the council. It is very important, and they're very active, and we appreciate that. So,
I move that we approve the resolution appointing 17 people to fill the membership positions on the Galveston Bay Council as recommended by the executive director.
I second. All those in favor?
Aye.
Motion carries. Ms. Smith, if you'll call the next item.
Item number 6 is the consideration of a resolution appointing one nominee to serve on the Municipal Solid Waste Management and Resource Recovery Advisory Council, and the executive director's staff is here to present the item.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. My name is Anju Chalese of the West Permis Division. With me today is Kayla Murray from Environmental Law Division. We're here requesting the appointment of new member to a new Municipal Solid Waste Management and Resource Recovery Advisory Council. This advisory council is composed of 18 members who review municipal solid waste management policies and make recommendations to the executive director and commission. The request for nomination was published in Texas Register on August 19, 2022. A total of 3 applications were received for 2 out of 4 specific qualifying positions. In your materials, you have a listing of vacant position and biographical information of the recommended applicant. Staff reviewed the applications received to ensure the appointee meets statutory requirement for the selected position. The recommended applicant meets the position of an elected official from a county with a population less than 150,000. The appointment will expire on August 31st, 2027. Thank you for your consideration of this matter, and we are here available to answer any question at this time. Thank you.
Thank you. I don't have any questions. Commissioner?
What can we do to help locate and identify eligible applicants? Seems like it's a really tough set of, we've got two important different councils to our agency back to back, and it struck me that they were all elected officials that were spots we were trying to fill, and unfortunately only one we had an eligible applicant, but I'm pleased to have that applicant there. So what could we do to help from our end? I appreciate noticing it publicly.
We also advertise this to the TCQ social media and MISRAC website and all.
Is it a time-limited opportunity to join the council, or can I carry this in a coat card and try to ask people if they're interested to join as I encounter them in the legislature?
Anything to get word out would be
Great.
appreciated. Thank you.
Sounds like we can revisit and add people as we find interested and willing group members. Good. No questions.
Thank you. Ms. Smith, has anyone signed in on this item?
No one signed in.
OPIC, thoughts?
Again, OPIC supports approval of the resolution as recommended by the ED.
Thanks. I agree with ED and OPIC on this one. You know, this appointment is a little specific. It's for an elected official from a county with a population of less than 150,000. So thank you to Caldwell County Judge Hoppy Hayden for applying. They fit the bill, and I'm ready to move forward with adoption.
Likewise, I move we adopt the Executive Director's resolution appointing Caldwell County Judge Hoppy Hayden to the Municipal Solid Waste Management and Resource Recovery Advisory Council to fill the position of an elected official from a county with a population less than 150,000, set to expire on August 31st, 2027.
I second. All those in favor?
Aye.
Motion carries. Ms. Smith, if you'll call the next items.
That takes us to the enforcement docket, items 7 through 21. And I will note that we have a pending motion also to remand item 14 from the executive director. The executive director's staff is here to present these matters.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. Excuse me. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Michael Parrish, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 7 through 13 and 15 through 21. The total assessed administrative penalties are $267,329, with $18,591 deferred. $152,310 applied towards supplemental environmental projects, and $96,428 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you. I don't have any questions, Commissioner Janeka.
Likewise. Thank you.
Ms. Smith, do we have anyone signed in on these items?
We do not.
Okay. OPIC, thoughts?
OPIC supports adoption of these enforcement orders as presented by ED staff.
I'm in agreement. I'm prepared to move forward with the exception to remand item 14.
Likewise, and I have that motion. I would move that we remand item 14 to the Executive Director for further case development and adopt items 7 through 13 and 15 through 21 as recommended today by the Executive Director.
I second. All those in favor?
Aye.
Motion carries. Thank you all. Ms. Smith, if you'll call the next item.
Item 22 is the consideration of the monthly enforcement report, and the executive director's staff is here to present this item as well.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me are Michael Parrish of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We're here to present the monthly enforcement report for fiscal year 2023 through January. There were 438 effective administrative orders issued, and of those, 63 contained supplemental environmental projects. These orders assessed a total of $5,901,758 in penalties, with a payable amount of $3,632,321. $1,507,398 are to be paid towards supplemental environmental projects. 5,428 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 898 enforcement action referrals have been received. There are 2,227 pending administrative orders with 825 cases that are on the backlog. 189 cases are pending at the Attorney General's office for representation in district court, and 4 judgments have been issued. 2,199 cases are being tracked for compliance. We have included for review a summary of OCE investigative activities for fiscal years 2021, 22, and 23. We are available to answer any questions you may have.
Thanks for the report. I don't have any questions or comments. Commissioner, do you?
I was glad to see that it looked like the rate of steadily increasing backlogged orders flattened over this reporting period. And that was a surprise for me, frankly, given that we're in the midst of discussion of our agency sunset, many difficult conversations that I can imagine are putting demands on your staff. So I just would invite you to add anything or comment there. Was that a success story or just part of our agency's process moving forward?
Well, we're continuing to implement procedures and efficiencies wherever we can with the staff that we have. It has been an impact having operating so long with reduced staff, but we're targeting the oldest cases, those greater than 2 years old, and making sure that we're addressing those, and that's a small number remaining. But there have been legislative commitments have been also a bit strenuous for us.
Yeah.
But we've maintained those and been working through all bill analysis, as you had mentioned earlier. So we continue to have the high number of vacancies, and back in January when we last reported, we were about 32% vacancies, and now we have 29%. So we have a slight improvement there, but we're still working with trying to hire and keep the staff that we're hiring, and just making sure that they're trained up as well, because we're excited to have them, but also recognizing that that's also an impact to us, as well as trying to get them trained up as TCEQ employees, and then being able to develop cases and support the other division functions.
Thank you.
Ms. Smith, has anyone signed in on this item?
No one is signed in.
Thank you. Comments from OPIC, if any?
No, Commissioners, we do appreciate the report, and I don't have any comment right now.
Yeah, I don't have any comments other than just thanks for that brief little update on where you are in your vacancies. That's, a decrease is great news, and your division always does great work, and so I'm appreciative of the employees that are there and that are working so very hard. There's no action on this item, so Ms. Smith, if you'll please call the next items.
Items 23 through 26 are for closed session, and the commission will not be meeting in closed session today.
With that, it is 10:37 a.m. and the commission stands adjourned. Agenda stands adjourned.